Picture this. A 19-year-old walks into a courtroom wearing jeans and a modest blazer, her hair pulled back in a simple ponytail, carrying a worn backpack instead of a leather briefcase. The judge takes one look at her and assumes she's a defendant, maybe a college student caught with a fake ID or facing a minor traffic violation. He doesn't bother hiding his condescension when he asks if she has legal representation. Her response? The smirk that crosses his face in that moment, the dismissive chuckle, the patronizing tone when he suggests she might want to get a real attorney. That moment would haunt him for the rest of his career. Because what Judge Richard Carmichael didn't know, what he couldn't have known from his elevated bench in that Boston municipal courtroom, was that he was facing one of the most brilliant legal minds to graduate from Harvard Law School in a decade. This is the story of Zara Mitchell, the 19-year-old attorney who walked into court expecting justice and walked out teaching a veteran judge the most humbling lesson of his life. This is about ageism, brilliance, and what happens when the system underestimates someone who's spent their entire life being underestimated. To understand how a 19-year-old ended up as a licensed attorney facing off against a judge with 30 years on the bench, you need to understand that Zara Mitchell was never an ordinary child. Born in Cambridge, Massachusetts to two professors, her mother taught constitutional law at Boston University. Her father was a philosophy professor at MIT. Zara grew up in an environment where intellectual discourse was the family language. By age 3, she was reading at a 5th grade level. By age 5, she was sitting in on her mother's undergraduate lectures, absorbing concepts about judicial review and constitutional interpretation that most adults find incomprehensible. By age 7, she'd read the entire Constitution, the Federalist Papers, and had started working through her mother's law school textbooks. But intelligence alone doesn't make someone a prodigy. What made Zara exceptional wasn't just her ability to absorb information, it was her capacity to analyze, synthesize, and apply legal principles with a sophistication that stunned everyone who encountered her. Her parents, recognizing that traditional schooling would bore her into academic apathy, made the difficult decision to homeschool her, allowing her to progress at her own pace while supplementing with college courses. Zara took her first college course at age 11, an introduction to legal theory at a local community college. The professor, initially skeptical about allowing a child in his classroom, became her strongest advocate after she scored the highest on every exam and wrote a final paper that he submitted to an academic journal. It was published. By age 13, Zara had completed enough college credits to be admitted to Harvard as a full-time undergraduate student. She was the youngest person admitted to Harvard in over 40 years. The media attention was intense. Articles about the child genius, television interviews where hosts treated her like a circus act rather than a serious student, endless speculation about whether she was being pushed too hard by ambitious parents. But anyone who knew Zara understood that the drive came entirely from within. She wasn't being pushed by her parents. She was pulling them along, constantly seeking more challenges, more complexity, more opportunities to engage with the law at deeper levels. Her undergraduate years at Harvard were marked by the same pattern. Initial skepticism from professors who assumed a teenager couldn't possibly contribute meaningfully to upper-level seminars, followed by grudging respect when she consistently demonstrated insights that exceeded those of students a decade older. She graduated summa cum laude at age 16 with a degree in government and a minor in philosophy. Her senior thesis on Fourth Amendment privacy rights in the digital age was published in the Harvard Law Review, an almost unprecedented achievement for an undergraduate. Law school was the natural next step, though it came with unique challenges. Harvard Law School doesn't typically admit 16-year-olds, regardless of their credentials. The admissions committee debated her application for months. Some argued that emotional maturity matters as much as intellectual capacity in legal education. Others pointed to her undergraduate performance and asked what more evidence they needed that she could handle the rigor. Eventually, Dean of Admissions Margaret Foster made the decision personally. We admit students who we believe will contribute to the legal profession in meaningful ways. Everything in Zara Mitchell's record suggests she'll do exactly that. Zara entered Harvard Law School at 16, becoming the youngest law student in the school's modern history. The media circus intensified. Legal commentators debated whether someone so young could understand the nuances of legal reasoning. Critics argued that life experience matters in law, that understanding human nature and consequence requires maturity that transcends book knowledge. Some suggested the whole thing was a publicity stunt, that Harvard was admitting her for the media attention rather than her qualifications. Zara ignored all of it. She attended class, participated in seminars, briefed cases, and consistently demonstrated that her age was irrelevant to her analytical capabilities. Her 3 years of law school followed a familiar pattern. Initial skepticism from professors and classmates, exceptional performance that silenced the skeptics, and a growing reputation as someone whose legal mind operated at a level that transcended age considerations. She was invited to join the Harvard Law Review not as a diversity admission or a curiosity, but because her scholarly writing was simply better than most of her older peers. She participated in moot court competitions where she regularly outperformed third-year students who had years more life experience. And she graduated at age 19. Not just graduated, but finished in the top 5% of her class with job offers from some of the most prestigious law firms in the country. But passing the bar exam and becoming a licensed attorney at 19 presented yet another hurdle. Most states require bar candidates to be at least 18 years old, but some have additional requirements or discretionary review processes for exceptionally young applicants. Massachusetts, fortunately, had no age requirement beyond the ability to demonstrate competence. Zara sat for the bar exam in July, 3 weeks after her 19th birthday. She passed on her first attempt with a score in the 95th percentile. By September, she was a licensed attorney in the Commonwealth of Massachusetts, the youngest in the state's history. The question then became, what does a 19-year-old attorney do with a license to practice law? The prestigious firm offers were tempting, but Zara had watched her mother dedicate her career to public interest law and civil rights advocacy. She'd seen how corporate law could be intellectually stimulating, but often felt disconnected from justice in its purest form. So instead of joining a firm where she'd spend years reviewing contracts and filing motions, Zara made a choice that surprised everyone. She accepted a position with the Massachusetts Civil Liberties Union, a nonprofit organization that handles civil rights cases, constitutional challenges, and advocacy for marginalized communities. The pay was a fraction of what corporate firms offered, but the work meant something. And crucially, it meant she'd be in court, actually litigating cases, not just researching them. The case that would bring Zara face-to-face with Judge Carmichael began 3 months after she started at the Civil Liberties Union. Her client was Marcus Rodriguez, a 34-year-old public school teacher who'd been arrested during a peaceful protest against education budget cuts. The protest had been entirely lawful. Proper permits obtained, peaceful demonstration, no violence, no property damage. But at the end of the demonstration, as protesters were dispersing, a confrontation occurred between a small group of protesters and police officers. Marcus, who hadn't been involved in the confrontation but was nearby, was swept up in the mass arrests that followed. He was charged with disorderly conduct, resisting arrest, and assault on a police officer, charges that could cost him his teaching license, his career, and potentially his freedom. The evidence against Marcus was thin and contradictory. The police report claimed he'd shoved an officer, but the officer couldn't definitively identify Marcus from a lineup. Video footage from the scene showed Marcus standing peacefully with his hands visible when officers approached him. Witness statements from other protesters confirmed that Marcus had been attempting to leave the area when he was grabbed by police. It was, in Zara's assessment, a classic case of false arrest and malicious prosecution, a teacher targeted because he'd exercised his First Amendment rights, then charged with serious crimes to justify the arrest after the fact. The Civil Liberties Union assigned Zara to the case not because they thought it was an easy win for a new attorney, but because their more senior lawyers were overloaded with cases, and this one, while important to Marcus, wasn't the kind of high-profile constitutional challenge that demanded their most experienced litigators. It was, in the calculus of a nonprofit with limited resources, a training case, an opportunity for their youngest attorney to get courtroom experience with a case that had a reasonable chance of success and relatively low stakes if things went wrong. What they didn't anticipate was that this training case would become a flashpoint for conversations about judicial bias, ageism in the legal profession, and the assumptions that permeate our justice system. Zara prepared for Marcus's hearing with the same thoroughness that had characterized her entire academic career. She reviewed every piece of evidence multiple times. She watched the video footage frame by frame, noting the exact position of every person visible in the shot. She interviewed witnesses and took detailed notes. She researched every relevant case precedent on false arrest, First Amendment protections for protesters, and probable cause requirements for arrest. She prepared a motion to dismiss based on insufficient evidence, complete with supporting memoranda that cited over 50 cases and included a detailed timeline reconstructing the events of that evening. The motion was 28 pages of tightly argued legal reasoning that would have been impressive coming from an attorney with decades of experience. Coming from a 19-year-old handling her first criminal defense case, it was extraordinary. The hearing was scheduled for October 15th in Boston Municipal Court, Judge Richard Carmichael presiding. Carmichael was a veteran of the bench, appointed 15 years earlier after a career as a prosecutor, known for his no-nonsense approach to criminal cases and his tendency to defer to law enforcement officers' testimony. He was, by reputation, a law and order judge who believed that most defendants were guilty and that defense attorneys were simply doing their job of throwing up procedural roadblocks. Zara arrived at the courthouse at 8:30 a.m. for the 9:00 a.m. hearing, giving herself time to meet with Marcus and review their strategy one final time. She was dressed professionally but simply. A blazer she'd bought at a thrift store, a white blouse, dark pants, flats rather than heels, because she'd never gotten comfortable in heels and saw no reason to start now. Her hair was pulled back in a ponytail. She carried her materials in a backpack rather than a briefcase because that's what she'd used throughout law school, and it held everything she needed. She looked, to anyone who didn't know better, like a college intern or a law student observing court proceedings, certainly not like an attorney about to argue a motion to dismiss criminal charges. When Zara entered the courtroom, the prosecutor, Assistant District Attorney Thomas Bergen, a man in his late 40s who'd been trying cases since before Zara was born, did a visible double-take. He approached her, clearly confused. He asked, his tone suggesting he assumed she was Marcus's girlfriend or family member. Zara smiled politely. "I'm here representing Mr. Rodriguez." Bergen's expression shifted from confusion to barely concealed amusement. "You're the attorney?" Zara kept her smile in place, though her voice took on a slightly sharper edge. "I don't have a supervisor. I'm the attorney of record." Bergen shook his head, still smiling like he'd just heard a good joke. "This should be interesting," he muttered before walking back to the prosecution table. She squeezed his hand reassuringly. "Trust me." But even Marcus, who'd been grateful to have any attorney willing to take his case, looked uncertain about his chances with someone who barely looked old enough to be out of high school representing him against criminal charges. When Judge Carmichael entered the courtroom at 9:03 a.m., everyone stood. He took his seat, shuffled some papers, and looked up at the defense table. His eyes landed on Zara, then immediately moved past her, clearly looking for the attorney. When he didn't see anyone else, his brow furrowed. He asked, his tone already impatient. Zara stood. "I'm here, Your Honor." Carmichael stared at her for a long moment, his expression cycling through confusion, disbelief, and finally settling on condescending amusement that he didn't bother to hide. He asked, a question that had nothing to do with the case, and everything to do with his assumptions about who could be competent to practice law. Zara had anticipated this question. She'd faced variations of it in every professional setting she'd entered. "I'm 19, Your Honor." Carmichael leaned back in his chair, a smirk playing at the corners of his mouth. 19. Zara kept her voice level, professional. "Yes, Your Honor." Carmichael shook his head slowly, as if he were a parent dealing with a child who'd just announced plans to build a rocket ship in the backyard. "Young lady, I admire your ambition, but criminal defense is serious business. Does your client understand that he's being represented by someone with—" The condescension dripped from every word. "Limited experience. Not no experience. Zara technically had no courtroom experience at all, but limited, as if her age automatically meant incompetence. Marcus, to his credit, spoke up from his seat. "Your Honor, Ms. Mitchell is my attorney of choice." Carmichael waved his hand dismissively. "Mr. Rodriguez, I strongly suggest you obtain more experienced counsel. Perhaps Ms." This was the moment. This was the choice point where Zara could either accept the judge's condescension, maybe ask for a continuance while she got a more senior attorney from the Civil Liberties Union to co-counsel with her, or she could stand her ground and insist on her right to represent her client. She chose the latter. "Your Honor, with respect, I am licensed to practice law in Massachusetts. I have no supervisor. I'm the attorney of record on this case. My client has expressed confidence in my representation." The temperature in the courtroom seemed to drop. Judge Carmichael's expression shifted from amused condescension to genuine irritation. He wasn't used to being challenged, especially not by someone who looked like they should still be worried about SAT scores. "I'm simply concerned about your client's interests, counselor," he said, emphasizing the last word in a way that suggested he found it ridiculous to apply that term to someone Zara's age. "But if you insist on proceeding, then let's proceed. Though I'm warning you now that I don't have patience for frivolous motions or poorly argued legal theories. You'll have 10 minutes to convince me why these charges should be dismissed." 10 minutes. In a hearing that should have been allocated 30 minutes minimum for a motion this complex. It was a clear signal. He wasn't taking her seriously, wasn't going to give her a fair hearing, was already planning to deny the motion before she'd said a single word of argument. But Zara didn't flinch. She opened her binder, took a breath, and began what would become one of the most talked-about legal arguments in Massachusetts municipal court history. Zara began her argument not with the facts of the case, but with a question, a technique she'd learned from watching her mother litigate civil rights cases, a way of framing the legal issue that immediately forced the judge to engage with the core constitutional principle at stake. "Your Honor, the question before this court is simple. Can a citizen be arrested for exercising their First Amendment rights, then charged with crimes to justify that arrest retroactively, even when the evidence clearly shows they committed no offense?" That's what happened to Mr. Judge Carmichael interrupted before she could continue. "Counselor, Mr. Rodriguez was arrested during a riot." It was a typical judge's shortcut, accepting the prosecution's framing of the event as a riot, when in fact it had been a lawful protest that became chaotic only in the final minutes, and even then only involving a handful of people nowhere near Marcus. But Zara had prepared for this. "With respect, Your Honor, characterizing a lawful protest as a riot doesn't make it so. The evidence, which I'm happy to walk through in detail, shows that Mr." She clicked a small remote she'd brought with her, and the courtroom's projection screen came to life with a still frame from video footage. Zara had done something that neither the prosecution nor the judge had expected. She'd created a visual presentation of her argument, complete with video evidence, timeline graphics, and case precedent citations. It was the kind of sophisticated presentation usually reserved for major trials with significant resources behind them, not preliminary motions in municipal court. Bergen, the prosecutor, looked genuinely surprised. Even Carmichael's expression shifted slightly, his condescension giving way to begrudging curiosity about what this teenager had put together. "This footage," Zara continued, advancing the video frame by frame, "shows Mr. Rodriguez at 3:47 p.m., 7 minutes before the alleged confrontation with police. Note his position. He's standing on the sidewalk, well away from the street where the police line has formed. His hands are visible. He's holding a sign but making no aggressive movements. At 3:49 p.m. here, he begins walking away from the area as the protest is ending. At 3:51 p.m., officers approach him from behind. At 3:52 p.m., without any verbal exchange or warning, an officer grabs his arm. Mr. Rodriguez turns, startled. Zara paused the video on a frame that showed Marcus face down on the pavement, hands being forced behind his back, with no evidence of any aggressive action on his part. The police report claims Mr. Rodriguez shoved Officer Maloney, then resisted arrest. This video shows no shove. What it shows is a man being grabbed without warning and immediately forced to the ground. That's not an arrest based on probable cause." Bergen stood, objecting. "Your Honor, the defense is making serious accusations against law enforcement officers without basis. The officer's testimony will show—" Zara cut him off, which was bold for any attorney in a courtroom, but especially audacious for a 19-year-old addressing a veteran prosecutor. "The officer's testimony contradicts the video evidence, which is precisely the point." Judge Carmichael held up his hand, stopping Bergen's response. He was leaning forward now, actually watching the screen, his earlier dismissiveness replaced by what looked like genuine attention to the evidence. "Continue, counselor," he said, and this time the word counselor didn't carry quite the same mocking edge. Zara advanced to the next segment of her presentation, a legal analysis of probable cause requirements for arrest. She cited Commonwealth v. Stout, Commonwealth v. Hasten, and Atwater v. City of Lago Vista, weaving the case precedents together to build an argument that the arrest lacked probable cause from the start, making all subsequent charges fruit of an unlawful seizure. But where Zara's presentation moved from impressive to extraordinary was in her analysis of qualified immunity and municipal liability. She didn't just argue that Marcus should have the charges dismissed. She built a case for why the arrest constituted a constitutional violation that could expose the city to civil rights liability. "Your Honor, under the framework established in Hope v. Pelzer and further clarified in Taylor v. Riojas, qualified immunity does not protect officers who violate clearly established constitutional rights. The right to peacefully protest is clearly established. The requirement of probable cause for arrest is clearly established. Officer Maloney violated both." She was arguing not just for her client, but against the entire prosecutorial strategy. She was telling the judge that denying her motion would expose the city to a lawsuit that they would likely lose. It was a bold move, threatening litigation while arguing a preliminary motion, but it was also brilliant because it gave Judge Carmichael a pragmatic reason to grant the motion beyond just the legal merits. Zara had recognized that this judge responded to practical consequences more than abstract constitutional principles, so she'd tailored her argument to speak his language. 8 minutes into her 10-minute allocation, Zara concluded with a rhetorical flourish that would be quoted in legal blogs and civil liberties newsletters for months afterward. "Your Honor, Marcus Rodriguez is a public school teacher. He attended a protest about education funding because he cares about his students and his profession. He exercised his constitutional rights peacefully and lawfully. For that, he was arrested, charged with crimes he didn't commit, and now faces losing the career he's dedicated his life to building. The evidence before this court conclusively demonstrates his innocence. The law requires dismissal of these charges. And justice, the principle that supposedly guides every decision made in this courtroom, demands that we acknowledge when the state has overreached, when citizens have been wronged, and when continuing a prosecution would compound rather than correct an injustice. The courtroom was silent. Zara returned to her seat, her heart pounding but her expression calm. Marcus was staring at her with something approaching awe. The prosecutor looked like someone who'd just realized they'd brought a knife to a gunfight. And Judge Carmichael sat motionless at his bench, staring at the screen where the video was still frozen on Marcus being forced to the ground, apparently deep in thought about what he'd just witnessed. After what felt like an eternity but was probably only 30 seconds, Carmichael looked at the prosecutor. "Mr. Bergen, I'm going to give you an opportunity to respond to the defense's motion." Bergen stood, clearly uncomfortable. "I've reviewed the materials, Your Honor, but—" Carmichael interrupted him. "That's not what I asked. Have you watched this specific footage that Ms. Bergen hesitated?" Carmichael's expression darkened. "You may not have seen this particular angle. The angle that clearly shows your defendant did nothing to justify arrest. The angle that contradicts the police report that forms the basis of these charges." The temperature in the courtroom shifted. This was no longer a judge dismissing a young attorney's frivolous motion. This was a judge realizing that he'd almost let a wrongful prosecution proceed because he'd been too busy being condescending about the defense attorney's age to actually look at the evidence she'd presented. Bergen, sensing the direction this was headed, attempted damage control. "Your Honor, even if there are questions about the initial arrest, the defendant still faces charges of disorderly conduct and—" Carmichael cut him off again. "Mr. Bergen, I've sat through defense motions to dismiss in this courtroom for 15 years. I've denied most of them. I've been skeptical of defense attorneys claiming their clients were wrongly arrested or that police reports were inaccurate. But I've never had a defense attorney present evidence this clear, this well-organized, and this compelling. Ms." He turned to Zara, and for the first time since she'd walked into his courtroom, he looked at her with something other than condescension. It wasn't quite respect, not yet, but it was at least recognition that he'd been wrong about her. "Ms. Mitchell, I owe you an apology. When you walked in here, I made assumptions based on your age. I assumed you weren't prepared. I assumed you didn't understand the complexity of criminal procedure. I assumed you were in over your head. I was wrong on all counts. Your presentation was one of the most thorough and well-argued motions I've seen in this courtroom." Zara, who'd spent the entire argument maintaining perfect professional composure, allowed herself a small smile. Carmichael continued, "The motion to dismiss is granted. All charges against Mr. Rodriguez are dismissed with prejudice. Mr. Bergen, I'm directing the District Attorney's Office to review its procedures for evidence evaluation in protest-related arrests. If you're filing charges that might infringe on First Amendment rights, I expect your office to thoroughly review all available evidence before arraignment. And Ms. Mitchell, I suspect I'll be seeing you in my courtroom again." It was as close to a mea culpa as judges typically offer, and it was enough. Marcus Rodriguez walked out of that courtroom a free man, his criminal record clear, his teaching license safe, his faith in the legal system partially restored. The prosecutor walked out having learned a humbling lesson about taking defense attorneys seriously, regardless of their age. And Zara walked out having won her first case in spectacular fashion, though she'd later say the victory felt less satisfying than it should have, because it came only after having to overcome prejudices that shouldn't have existed in the first place. The immediate aftermath of the hearing was relatively quiet. Marcus went back to teaching. Zara went back to her office at the Civil Liberties Union and started preparing for her next case. But word travels fast in legal communities, especially when something unusual happens. Within a week, attorneys who'd been in the courtroom that day were telling colleagues about the teenage attorney who'd destroyed a prosecutor's case with a 10-minute PowerPoint presentation. By the end of the month, the story had spread through the Massachusetts legal community with the kind of embellishment that comes with repeated telling. Some versions had her citing 50 cases from memory. Others claimed the judge had initially refused to let her argue at all. Still others insisted she'd made Bergen cry. He hadn't, but he definitely looked like he wanted to. The Boston legal blogs picked up the story 2 months later when a reporter covering the courthouse heard about it from a clerk and decided to investigate. The article, titled 19-Year-Old Attorney Wins Motion to Dismiss After Judge Questions Her Credentials, went viral within legal circles. National publications followed. Law school professors used the case as an example in legal ethics courses about implicit bias and the importance of judging arguments on their merits. And inevitably, the media attention brought scrutiny of Judge Carmichael's initial reaction. To his credit, Carmichael didn't hide from the criticism. When contacted by reporters, he gave a statement that was remarkably honest. "I made a mistake. I looked at a young woman and assumed she wasn't qualified to be in my courtroom. That assumption was based on age bias, and it was wrong. Ms. Mitchell's argument was exceptional, and it forced me to confront my own prejudices about what an attorney should look like. I've been a judge for 15 years, and I thought I was beyond making those kinds of assumptions. This experience taught me that we all have blind spots, and mine was assuming that youth equals inexperience or incompetence. I'm grateful to Ms." His candor earned him respect from many in the legal community who appreciated a judge willing to admit error. But it also sparked broader conversations about ageism in the legal profession. Articles appeared in legal journals examining the challenges faced by younger attorneys, not just prodigies like Zara, but the typical law school graduate entering the profession in their mid-20s. Studies were cited showing that younger attorneys, particularly women, face consistent skepticism about their competence regardless of their actual qualifications. Panel discussions at Bar Association conferences addressed implicit bias in courtroom interactions, and several states began implementing judicial training programs specifically focused on recognizing and counteracting age-based assumptions. For Zara, the attention was complicated. On one hand, she'd proven her point. She was a competent attorney who deserved to be taken seriously. On the other hand, the story of the teenage attorney threatened to define her entire career, reducing her from a skilled lawyer to a novelty act. She gave a handful of interviews in the months after the case, but eventually stopped because reporters were more interested in her age than her legal work. "I don't want to be famous for being young," she told one interviewer. "I want to be respected for being good at what I do." The Civil Liberties Union saw a spike in donations and case referrals after Zara's story went public, with many donors specifically citing their desire to support an organization that hired attorneys based on competence rather than conventional qualifications. Zara's caseload increased dramatically as more people requested her specifically as their attorney. Marcus Rodriguez became something of an advocate himself, speaking at education policy events about his experience and the importance of legal representation for citizens exercising their constitutional rights. He'd remained in touch with Zara, and when asked about his attorney, he'd tell anyone who'd listen. "She saved my career, she saved my life, and she did it while dealing with a judge who didn't take her seriously until she forced him to." Judge Carmichael, for his part, became an unlikely advocate for addressing bias in the judiciary. He started speaking at judicial conferences about his experience, using his own mistake as a teaching moment for other judges. "We talk a lot about racial bias and gender bias in the courts," he'd say in these presentations. "But we don't talk enough about age bias, about the assumptions we make when someone doesn't fit our mental image of what an attorney should look like. I almost denied a clearly wrongful prosecution because I was too focused on the attorney's appearance to actually listen to her argument. That should never happen." Today, Zara Mitchell is 22 years old. She's argued over 40 cases with the Massachusetts Civil Liberties Union. She's won appellate decisions that have set precedent on First Amendment protections and qualified immunity standards. She's become one of the most sought-after civil rights attorneys in Massachusetts despite, or perhaps because of, her youth. Law students study her arguments in constitutional law classes. Attorneys seek her advice on motion strategy and evidence presentation. And judges who encounter her in court know better than to make assumptions based on her age. But her story resonates beyond the legal profession. Because what happened in that courtroom wasn't really about law, it was about the assumptions we make about competence, capability, and who deserves to be taken seriously. Judge Carmichael looked at a 19-year-old woman and assumed she couldn't possibly be an effective attorney. He was wrong, and his willingness to admit that wrongness, to learn from it publicly, became almost as important as Zara's brilliant legal argument. We live in a world that constantly equates age with authority and youth with inexperience. We assume older means wiser, that positions of responsibility should be reserved for people who've accumulated decades of life experience. And sometimes those assumptions are reasonable. Experience does matter in many contexts. But sometimes those assumptions blind us to brilliance that doesn't fit our preconceptions. Sometimes we miss extraordinary talent because we're too focused on what someone looks like to actually listen to what they're saying. Zara Mitchell didn't just win a motion to dismiss that day in court. She won something more important, recognition that her youth doesn't define her capabilities. She forced a veteran judge to confront his biases and admit his mistakes publicly. She reminded an entire legal community that competence comes in unexpected packages, and she proved that sometimes the most powerful voice in the room belongs to the person everyone underestimated. If you're watching this and you've ever been underestimated because of your age, whether you're too young, too old, or simply not the right age for the position you're seeking, let Zara's story remind you that other people's assumptions don't define your actual capabilities. Your age is a number. Your competence is what you demonstrate through your work. Anyone who can't see past the first to recognize the second has revealed more about their limitations than yours. If you're in a position of authority, whether a judge, teacher, manager, or anyone whose decisions affect other people's opportunities, remember Judge Carmichael's lesson. He was a good judge who made a bad assumption. He had the humility to admit it and the integrity to learn from it. But how many others in power make the same mistake and never realize it because the people they underestimated never get the chance to prove them wrong? How many brilliant minds are dismissed? How many capable people are denied opportunities? How many Zaras are told to get a real attorney and never have the platform to show they are the real attorney? Here's what I want you to do. Share this story with someone who's been underestimated. Share it with someone who underestimates others. Share it with young people who are told they're not ready, not experienced enough, not old enough to be taken seriously. And share it with people in power who need a reminder that competence comes in unexpected packages. Drop a comment telling me about a time you were underestimated, or a time you realized you'd underestimated someone else. What did you learn from that experience? How did it change the way you see people? This conversation matters because these assumptions affect real lives, real careers, real justice. Hit that like button if you believe ability matters more than age. Subscribe to this channel for stories about people who refuse to let others' limitations define their possibilities, about moments when the system gets it wrong and individuals get it right, and about the power of proving yourself when everyone expects you to fail. Zara Mitchell walked into that courtroom as a teenager. She walked out as an attorney who earned respect the hard way, by being undeniably brilliant when everyone expected her to be unprepared. She didn't ask for special treatment. She didn't want fame for her age. She just wanted to do her job and represent her client with competence and integrity. She did exactly that. And in the process, she taught a judge, a prosecutor, and everyone watching that sometimes the most dangerous assumption is the one you don't even realize you're making. Don't underestimate people because of their age. Don't let others underestimate you because of yours. And remember, the next time someone walks into a room looking different than you expected, maybe, just maybe, you should listen to what they have to say before deciding they don't belong there. Zara Mitchell proved she belonged. Now it's on the rest of us to create a world where she wouldn't have had to.